Hello and welcome to Business Beat on 90.5 WICN. My name is David Ginsburg. Normally you would hear Giselle Rivera-Flores introduce herself. She is out this week, but I'm excited to welcome what's become a recurring guest on WICN's Business Beat from PKF O'Connor Davies, Laura Barooshian. Welcome back to the show, Laura.
Thank you, David. Thanks for having me back.
We're excited to welcome you back. It's an interesting time certainly in our financial world, given what's gone on in interest rates and economic news and so forth. And the reason we wanted to talk today is we want to discuss estate planning. And before we get into some specifics, for the people that are listening that may not be familiar yet or kind of a vague notion of what estate planning really is, I want to just get a general explanation from you because I think there's a misconception that estate planning is only for people of significant wealth, and that really isn't the case.
Yeah, I think you hit it exactly right, David. Estate planning applies to everyone, especially here in Massachusetts, where Massachusetts does not follow the federal estate rules per se, and that we have our own limitations. Now, those were revised back in October, which was really great and very taxpayer friendly, but an estate plan is something that everybody should have.
And I do want to talk about what some of those changes to the laws are and why the Massachusetts laws are not reflective in whole of what the federal government's laws are. But for WICN, with an audience on this radio station that skews 50 plus for sure, we know that we have a lot of affluent listeners in our audience. And unfortunately, a lot of folks don't make an estate plan. They don't draw up a will. They don't really plan for the end. And it ends up causing havoc in the family. And on top of your passing, it can drag out and lead to a lot of dissension in the family, and probate can then tie you up for years at a time and a lot of legal expenses. So if people don't yet have an estate plan, what's a great starting point for them to get going?
Yeah, I think you've got to imagine that once you've passed away, your family has enough to deal with, and families are very different today than they were, many years back. Certainly when I started practicing, things have really changed. But to have a plan in place removes some of the stress that might be caused from your passing. And some basic documents start with a will, a revocable trust, healthcare proxy, HIPAA form, power of attorney forms. Those are some documents that everybody should have. And depending on the state that you live in, because I think, we're obviously talking about Massachusetts, but the age of majority, you might want to consider having healthcare proxies and HIPAA forms for your children, adult children as well.
Yeah, and especially in an era now where, for many of us in Gen X and millennials as well, that are kind of that sandwich generation, you're taking care of elderly, aging parents while also raising children and trying to live your own life and plan for your own future and deal with the expenses that come with that. And it can be a tremendous amount of effort and expense to do those things. I do want to get some definitions on a couple of things that you mentioned, one of which is, of course, for people that may not be familiar, what is a revocable trust?
So a revocable trust is, I tell folks, it's like your alter ego. It's a trust that you have complete control over. You can make changes to it. You can edit it. You can modify it in any way, the assets that are in there. You have access to everything during your lifetime. What it does is once you've retitled the assets in the name of that revocable trust, they're going to avoid probate.
Okay.
And probate is, the state looking at your assets upon your passing, and it's a very public process. So having a revocable trust, and then most importantly, having those assets titled in the name of that rev trust will avoid probate, the public aspect of it, as well as the expense.
So for my own clarification here, when you say retitle as assets, does that mean you take your home and it is then listed as an asset of the trust rather than as an asset that belongs to you personally?
Correct. And that as well as any investment accounts that you have or any other material assets held in the name of that revocable trust.
Okay. All right. That makes sense. So because there is a difference in that there are irrevocable trusts that once it's in there, there's no changes that can be made. Excuse me. There's no amendments that can be added to it. Once it's set in structure, that's the finality of it.
Correct. Irrevocable trusts are very useful tools in estate planning as well, especially if you are more affluent. If you have assets that are over the Massachusetts estate limit or the federal estate limit, putting things into an irrevocable trust can remove them from your estate, which can be a great estate tax planning move. You don't have access to it anymore, though, and
Right.
that's the drawback. So you give it away, you've given it away. And I always remind folks that you want to be careful when you're looking at what should be into a revocable trust and what should be an irrevocable, because you don't want to in any way limit your own cash flow, your own needs. You don't want to have to go ask your kids for an allowance later.
Correct. And, it's interesting because we talked, or you mentioned a minute ago that folks that have to go through probate, it's a very public process. And I can think of, both Prince didn't leave a will, Aretha Franklin didn't have a will, or they had wills that she had left in couch cushions and things. And all of those assets suddenly are very public knowledge. It's court filings, and anybody can go and view what they had, what they didn't have. And it can be embarrassing to the family left behind on top of the stress of having lost a loved one and dealing with all of this. So step one, get a will together, create a revocable trust, get your HIPAA forms together if you don't have them, and designate both healthcare proxy and a power of attorney. And I do want to mention, or ask you rather, I know what a power of attorney is. I am one for my mom, but what does power of attorney mean in a legal sense for the offspring of people that need to plan for their estates?
Yeah, and the power of attorney, I should clarify too, the power of attorney is in place while the person's alive.
Mm-hmm.
So once the person's passed, then your personal representative is going to step in and be appointed and recognized by the court to settle your affairs. But the power of attorney holder, we had one from my in-laws as well, and it allowed us to, pay their bills, get access to online information, allowed us to go to the bank, allowed us to move assets, consolidate things, simplify things. And we needed to make some revisions to a will to clarify some things. And that allowed us to do those things while they were still with us.
So here's a question for you, and I'm not going to go into any specifics, but I'm dealing with a situation in my own family, and it's prompted some of these questions. And that, say there's a blended family, which is very common these days. People get remarried, adult children, the families blend. There's not always cohesion among both the offspring as adults and the parents. Sometimes can take diverse viewpoints on how their assets ought to be distributed accordingly. What options are there if someone has power of attorney? So let's say one parent's offspring has the power of attorney over the wealthier parent's assets, and they decide to start making material changes not based on need, but rather whether it's for revenge or even though they may believe themselves to be doing the right thing. What options do the rest of us have in combating that?
Yeah, that, unfortunately, we've seen some of that ourselves. Yep. And there can be, of course, legal action.
Yep.
So having, now you're into an argument, you've got lawyers involved with representing the power of attorney holder. The power of attorney holder has to, provide information that they've acted prudently. They've got the parent, in this case, their best interests at heart. It can be extremely expensive.
Yes, it can.
It's very, very time consuming and stressful. But yeah, at that point, if there's a disagreement with the power of attorney holder, then definitely having legal representation on all parts and getting to some kind of mediation. It may result in the fact that an independent power of attorney holder may need to be named, so that everybody can, get on board with,
yep.
Things being equitable and even and in the best interest of the in this case, a parent or, the person who the power of attorney is over.
Yeah, agree. And thank you for that, Laura. And that often, and let's just call this a hypothetical for no other reason. One parent has substantial wealth, the other one does not. So parent A has, a net worth, say it's $1.5 million in liquid assets. Parent B has a couple $100,000. The power of attorney for parent A suddenly starts making undue financial demands of parent B to deplete their assets to essentially subsidize their own inheritance. These are not uncommon situations, unfortunately. And it sounds like, if I'm hearing you correctly, that making sure that you have everything designed through your power of attorney, through your long-term plans for the trust itself, that all of these scenarios, and think through contingencies perhaps, so that as situations we live longer than we ever did generally, and illnesses that used to be fatal in 6 months can now drag out for years. So that can be another factor to address in these planning scenarios, and sort of thinking through the full line of what may happen. And ultimately, your goal is to protect the assets for the family and follow the wishes of the person who owns them.
Exactly. The priority first is whose assets do they belong to? Which parent, or in the case, which one of them? It's their property. as a power of attorney holder, you're executing in their best interest. So it's always understanding kind of what does that person need, what do they need today, and what they might need in the long run. Trust can help with that with the blended families as well, because trust can, for example, you've got one wealthy spouse, one moderately comfortable spouse. That the wealthier spouse passes away, the trust can dictate that the remaining spouse receives income during lifetime.
Yep.
It can be set amount, it can be defined. How is income defined? But the principal still belongs to the descendants of the spouse that passed in that blended family. That way the trustee is going to act in both parties' interests and preserve the principal, but also generate income to satisfy the payouts and things. So the trust can act as a way to put some guidelines or a governor around things as well, and help alleviate some of the unknown, who's got the right. A professional trustee might be the best way to go in that case, or again, a power of attorney holder, someone who isn't emotionally involved in the family and can be very unbiased.
Well, Laura, I think that's the key phrase, the emotionally uninvolved person, so that they're making decisions in a purely rational way as opposed to something driven by any other input, whether it's resentment from years back, a devolution of a relationship over years, whatever it may be. I think that's a critical factor to mention. And then I think from a larger standpoint, part of estate planning at this stage, so say you're in your 50s, life expectancy being what it is, you might have another 35 years to go. It gives you some peace of mind now, correct? And you're able to also make decisions in a way that are much more logical and rational than they would be if you're nearing the end and sort of making a much more emotionally driven decision. Is that accurate?
Absolutely. And I tell clients all the time that every situation is different. So the estate plan for two siblings can be very different. For two spouses can be very different. It depends on what every situation, how it's evolved, who's involved. Also, I tell folks estate planning is not a one and done. When I started my family, I just had the basic documents I mentioned earlier, and that was all well and good. At 4, my son was diagnosed with some special needs. Well, that changed my own plan so that there were some special needs trusts. There needed to be a different protocol. I needed to have more than just a family member to be a trustee because I needed someone with some financial savvy. So as each of us kind of looks at what is our estate plan today, you're right. At 50, that's very different than 70. That's very different than what it might need to be at 90.
Right. And very often you'll have adult children where a parent has helped one of the adult children in their lives much more substantially with financial resources than another. One person, whether it's to start a business, go back to school, or they're just, the chaos of life gets to them and they need more assistance than you might have anticipated when they were growing up. And you're able to create a trust that designates specifically to each person how they're going to be addressed, what they'll be receiving, and how it's going to be managed. And to your earlier point, I think it's important to note that assets in a trust, when it's being professionally managed, so let's say a spouse dies, the living spouse is granted essentially an income for the remainder of their lives. The principal remains in a trust and invested so that the interest remains in the trust for the family, so that the pot of money is still growing ultimately, and it's not just depleting the assets that are left behind. And a good estate plan will provide for those elements. Is that accurate?
Absolutely. That's a great way to put that. And provide creditor protection as well, and divorce protection, everything. So trusts are a really fantastic tool to use. There are some downsides to them as well, which we can talk about, but there are a well-crafted trust. It can be a really helpful tool in the estate planning process.
Thank you. And I think what I'd like to do, we're going to take a short break on Business Beat. When we come back, I want to talk about both the downsides of trust, but also especially for so many families in Massachusetts in the WICN audience that own businesses they want to pass along, or how the business is going to be wound down upon their passing, how to plan for those eventualities so that the business is protected as an asset, whatever it's going to stem from there, that the asset is protected for the for the people left behind, rather. We'll be back with more Business Beat on 90.5 WICN. David Ginsburg. I'm speaking with Laura Barooshian, who is a recent award winner for the Boston Estate Planning Council's highest honor, the BEPC Excellence Award. So first of all, congratulations on that. That's a big deal.
Thank you. It's a tremendous honor, and I'm very fortunate to join an amazing group of individuals who've been honored before me.
And you work for PKF O'Connor Davies, spoken before on Business Beat. This is always an illuminating conversation. I appreciate the time today. In the first half of the show, we discussed the benefits of trusts. I'd like to learn a little bit about why trust may not be, or what the downsides are, and what people ought to consider when they consider creating a trust for their estate plan. What are some risks that may be apparent within that?
Yeah, a couple of things to keep in mind is trusts will live past your lifetime. So they will continue on, and at some point they can become burdensome. They do add a level of complexity that maybe not any, folks who aren't, financially savvy or understand what the trust is. They do impose their own rules, as well as what was the settlor's wishes and what was written into that document. So those rules have to be followed. You may have too many beneficiaries in a trust. So one of the things that I've seen is, parent A and B start a trust and they've got 3 kids. Well, that works out great when the kids are 5, 6, 13, 18. But now they're 35 and 33, and one wants to start a business and one wants to buy a home and one wants to do volunteer work. How do you divide up a trust and keep things equitable so it can become a little bit more administratively burdensome to administer a trust that has multiple beneficiaries? You have to file tax returns, for many types of trusts. So there's a cost to that as well. So there can be some things that need to be analyzed when you're setting up a trust. What type of trust is the best one for any particular situation? And it may be different types of trusts in the same situation as well.
For sure. And I know one aspect that you mentioned, the beneficiary piece of this, as a nonprofit public radio station, we very often, not very often, we were hoping it would happen more often, but throughout the year, we sometimes will receive bequests from people's estates that have passed on, and it was through a family trust, family foundation, that there's different vehicles they can take. So sometimes it's a donor advised fund that when they pass along, the balance is distributed. Sometimes it's a straight bequest from the estate itself. But factoring those things in to honor the parents' wishes. And there are times that the living offspring will sort of balk at, well, I don't want to donate that amount of money to an organization. I want to keep it for myself because whether it's, I want to do volunteer work, or I need to start a business, or I'm just greedy and I just want the money myself. How do you coordinate around those potentialities?
Yeah, the document first sets what the wishes were of the settlor. The person who created the trust, the document's going to say that, charitable. What we often see is if it's not explicitly written in the document, that there was maybe some kind of side letter. There were some general guidelines given to the trustee that says, yes, I want to have a charitable beneficiary as part of my trust in addition to my children. And the side letter may say, my intention is to really support WICN for 3 years or something like that. So it may provide some guidelines that the trustee can factor in to the overall. Are we in an economic, upcycle or a down cycle?
Right.
What are the economics? The trustee's goal is to protect all of the beneficiaries and to, again, execute what the settlor wanted. So something like a side letter can be really helpful to give them some additional insight into what was your thinking when you created that trust.
Awesome. And I want to pivot a little bit. This is a business show. If someone in the WICN audience listening, that we know we have a lot of business owners in the community that are paying attention to us, and many of them, very often we see parents that the children don't want to take over the business for whatever reason, whether it's the burden of running a restaurant is too all-consuming for them, or they don't have the technical skills to run an automotive business, or they simply just have other interests in their lives and don't want to take over the business. What should people do to protect their business before they pass along, whether that's choosing a successor or preparing the business for sale?
Yeah, I think the very most important thing is you need to have a plan, and you need to communicate that plan with the interested parties. If your exit strategy is going to be, I'm going to work until my last day, do you want to have a prearranged sale document or something in place with a friendly competitor? Maybe you really like the auto shop that's also down the street and there's plenty of business for everybody, but the day that you pass away, you've got cars on the lot that need to be taken care of. Who's going to step in and do that? Who's going to be the next person? So communicating with your internal personnel, who's that general manager that's going to step in for you, and maybe having some prearranged, sale with a friendly competitor is a way to go. Maybe having a broker lined up so that if something were to happen, most of the time, I know we want to always think about how do we protect our clients, how do we protect our employees. You don't want them scrambling. They're again going to be in the same stressful situation, shock maybe that your family's in. That having a good plan for them is always a great thing. That they know what's going to happen if the worst was to happen. So who can step in and help them with the sale? Maybe it's the employees buying things out. Again, having a plan in place. Maybe there's insurance that helps the employees pay the estate to buy the business. So how much does that cost? Who bears the cost? Those are things to think about to have a plan in place for your successful business succession.
Yeah, thank you for that. That's quite an answer. And could that also include structuring ESOPs so that the employees can buy the business while you're still alive, and then it's structured in a way that you're still generating or receiving income from that entity, while you're still here?
Absolutely. And we see that question come up too, is does an ESOP make sense? And in some businesses, it's the perfect solution. And here at PKFOD, any of these discussions, whether it's with us, having those conversations about what is the plan with your general business counsel, with your estate attorney, with your CPA, with your financial advisor, every one of those individuals is going to bring something to that conversation. Your financial advisor is going to say, is it enough for you to live on if you're having a buyout during life?
Right.
Your estate attorney is going to say, what is the plan and what's the documents that need to administer that sale? The CPA is going to say, what kind of tax returns do we need to file for this? So every one of those individuals is going to bring something to the table in that discussion. It's important to have them all there.
For sure. And I'm glad you mentioned PKFOD in that response, because I want to make sure the audience is listening to WICN right now. Whether you are planning your estate at a personal level, or you have a business that you want to create a succession plan for, or some combination of both, how does PKFOD set themselves apart in this particular space?
Yeah, I think one of the things that we've been very cognizant of over our business time, is that we're going to be the business advisor, the accountant, the preparing the tax returns, that we understand and appreciate the value of having a cohesive team that advises the client. So we want to work with the attorneys. We're not going to draft the documents. Mm-hmm. We want to work with the insurance provider. We're not going to sell the policy. We're not going to manage the assets, but we want to understand what is the cash flow needs of a sale during lifetime. Do you want to travel? Do you want to buy a second home? What are you trying to do? Is charitable part of that sale? All of those things. So I think what sets us apart is really being part of that client team and appreciating what everybody brings to the table for the client.
Yeah. And again, you'll help people prepare for the end of their life. You're not doing the embalming.
Exactly. Exactly. Exactly.
One question. I had to inject some levity. We mentioned at the beginning of the show, you mentioned at the beginning of the show, rather, changes to state and federal tax laws that are impacting estate planning. Tax laws change every year, but there are some pretty substantial changes in the past couple of years. So please give us some highlights of what those changes are so the audience is aware of them if they haven't been previously.
Yeah, I think the biggest change here in Massachusetts that we've seen is the estate tax exemption in October changed to $2 million per person. So if you have a taxable estate of $2 million, only the first dollar after that $2 million will be taxable in Massachusetts. That's a big change from the formula that we had previously. So a couple has $4 million. Now we see that with, the price of real estate these days, retirement accounts, that can go pretty quickly. Yep. But still, it was very much in the taxpayers' favor, and it was a welcome change. Federally, we're looking forward actually to the end of 2025. The current rules are in place right now, and we're just shy of about $14 million per person of estate tax exemption. And that is going to reset on January 1st, 2026. And it's going to go back to what it was in 2017, adjusted for inflation. So somewhere probably around 7 million or so. So we're going to go from almost 14 million to about 7 million.
Wow, that's a big drop.
Big change.
Yeah.
It's a big change. And as the rules are written right now, we've got something happening in November that could change things. We've got all kinds of things. And one thing about taxes, it's never permanent. It can be changed. But as the rules are written right now, we're telling folks that, with us, is we're engaging our clients in those conversations now so that we aren't just scratching our heads next November saying, oh, what do we do now when we've got a month left to maybe make some changes?
I think we'll be scratching our heads regardless, but that's a different conversation.
But maybe that's a whole different show. So yeah, but I think no, we've got some time right now to do some thoughtful, careful planning. Especially if you have minor children and things, you want to be very thoughtful about your estate plan. So starting earlier right now is a good time.
For sure. And I want to clarify that exemption for Massachusetts now is $2 million. Federally, it's currently 14, but that's going to drop to 7 in 2026, minus any changes. That includes all assets. It's not liquid assets. That includes real estate that you may own. It may own a business, a car, whatever those pieces may be.
Absolutely. It's the current value on the date of your passing of all of your assets, less all of your liabilities. So that's your business, that's rental real estate, personal real estate. If you own your home jointly with your spouse, it's half of that property is includable. Everything that's in your name, retirement accounts as well, everything that you have that's yours is included in that gross estate number.
Which is kind of remarkable. And I'm curious, we're almost out of time, but I do want to ask a question about life insurance. And then how does that factor in? So someone creates a revocable trust, they have everything lined up according to what we've discussed in this episode, but there's a large life insurance policy with designated beneficiaries. How does that factor into the overall estate and tax planning?
Yeah, I'm so glad you asked, because life insurance has its own special type of trust. And it's referred to as an irrevocable life insurance trust. And when the trust owns the policy on you, that is actually excluded from your estate.
Oh.
Because the trust owns it. So it's a great topic to bring up with your estate attorney and find out, should you move existing policies into an ILIT, irrevocable life insurance trust, or should any new policies go into an ILIT?
Yeah, which is critical to know, because some of these policies can be worth a lot of money, especially for folks that have lived long lives rather than have policies designated for each grandchild, for example, to pay for college expenses down the line, or life insurance to leave to a spouse. That's going to be what they're going to be able to live on for the remainder of their lives. And I'd like to learn more in a little bit of time we have left. Explain a little bit what the ILIT is again, so that people have a better understanding, mainly me.
Yeah, it's a specific type of trust that just holds on to the life insurance policy. So if I were to say, okay, I'm going to go get a new policy today, I would have the owner of that policy be the trust that I've set up, and not myself personally. If I hold it personally, it's includable in my estate. But if the trust is the owner, it can still pay to my children. It can pay to my son's special needs trust or my husband. I can still designate all the beneficiaries I want that I would normally just put on the policy. I can put into the trust, but merely having it owned by the trust, administered by the trust, keeps it outside of my estate and can be a significant savings in estate tax.
Awesome. We have 30 seconds left, Laura. So before we let you go, Laura Barooshian, PKFOD, how do people get in touch with you and or PKFOD to discuss estate planning for themselves?
Yeah, you can find me and my partners in our private client services group at pkfod.com. We're also in Woburn, and you can Google us and find us there.
Thank you very much, Laura Barooshian, PKFOD. This is David Ginsburg at 90.5 WICN. Here's to good business.